Hi, everyone. My name is Vlad Genshu, and I am a civil jury trial lawyer here in Los Angeles, California. I've tried 13 civil jury trials to verdict, and I have another two civil jury trials that did not go to verdict. One settled during jury selection, and the other one settled right before I was to give my rebuttal. I want to talk to you today about the concept of leaning in, which is leaning into your case. There are some things in a plaintiff's personal injury case, and those are the cases that I try to verdict. I try those as civil jury trials here in LA County, done two in Orange County, and I've done one in San Diego County. And I want to talk to you about the idea of leaning in, which is there are some parts of your case which you might think on first blush are weaknesses, but in reality, they can very much be your strength. And I want to talk to you about the medical treatment and the lien. It's no secret that a lot of medical treatment in personal injury cases is performed on a lien. There's a lot of reasons for that. One of the reasons is oftentimes doctors that treat on a lien have a lot of experience with personal injury cases, and they have a lot of experience with the kind of treatments that are necessary. If you just go to an ER facility, an emergency room, that kind of case, that kind of medical provider, frankly, a lot of those medical providers are just triage. They're going to send you home unless you have a broken bone, a dislocated bone. They might do some imaging workup, but oftentimes they'll tell you to follow up with your doctor, follow up with a physical therapist, follow up with some other kind of a medical provider, which is where the kind of treatment that would be provided on a lien would often begin. So I want to talk to you about the concept of lien finance treatment and why I think a lot of personal injury lawyers are scared of it, and why I think that they want to hide the lien, if you will. And in reality, you can't, based upon the case of Kadir versus Figueroa. The lien is considered relevant, and the jury has the right to know about it. But I want to talk to you first about a couple concepts here, which the first concept is, and another lawyer told me this, a great civil jury trial lawyer and civil rights lawyer. He told me that, his name's Gabriel Levina, by the way, he's a great attorney. He said, cynicism kills plaintiffs' personal injury lawyers. Cynicism kills PI cases, they kill civil rights cases, they kill any kind of case where you are alleging that somebody hurt you, your client, and that you are trying to help your client. Cynicism, unfortunately, I don't want to get on a soapbox here, but it's very, very common in our society. And I think the reason it's common, unfortunately, is, we live in a tough society, right? It's hard to get by, and we don't have as much compassion or empathy as frankly, I think people had in past generations. So a lot of lawyers that even practice personal injury law, they might be very cynical. They're cynical because they're dealing with insurance companies who nickel and dime them every day. And they might become cynical about their own cases. Maybe they become cynical about their own clients because it's tough to get justice, right? The fact is that 95% of cases settle, and a lot of them settle for what they shouldn't. They should settle for a whole lot more. But if you have a cynical approach and somewhere in the back of your head, you're questioning what you're doing because you're not getting the results you want, that's not good for you, because you are doing the right thing. If your client is hurt and injured and they don't have health insurance, or you have a list of medical providers that can help them, you're not doing anything wrong by assisting them by going to those doctors. You're not doing anything wrong with that. The jury has the right to know that, but you're not doing anything wrong. So the idea that being cynical about that and saying, I got to hide that, I got to, tell the client something that, we didn't refer, that's not the right thing to do. First of all, you should never lie. Okay? Your client should never lie. You should never lie on the stand, period. And you're not doing anything wrong by helping somebody get legitimate medical treatment. If they're injured, they have the right to medical treatment. And if you can help them, assist them, especially if they're people that are often underprivileged and perhaps there's a language barrier. Perhaps they're scared to go into a certain kind of, medical doctor that they don't have any relationship with. Maybe they don't have health insurance, period. So don't be cynical about helping people. If that's your motivation to help people, don't buy into the insurance industry line of, there's a lien. Think about it for a second. What is a lien? It's a mortgage on a person's case. Are we cynical about the mortgage industry? Are we cynical about getting a mortgage on a house? He bought his house with a mortgage. No, you would never say that to somebody. You know what? That's not a real house. You say you own it, but the bank owns it. The mortgage company owns it. No, you don't. The entire idea of somebody paying cash for an entire house might not make any sense. You might not be able to do that. Most people, vast majority, can't do that. You're not cynical about that. Why would you be cynical about helping people get treatment when they can't afford to pay cash, or they don't have a PPO, or they don't have an HMO, or their HMO is not accepted? And here's another thing. A lot of doctors, a lot of primary care physicians, the minute they hear that there's a car accident involved, they're not going to take the case. They're not going to treat. Why aren't they going to treat? And the jury oftentimes doesn't know this, because behind the profession of medicine, there's the business of medicine. And then the doctor has to deal with the insurance company on his or her own, which means that they know that now there's going to be delayed payment, because the healthcare company, the PPO, might say, "Oh, is this a car crash? Oh, we might not cover that. Send that over. It's in litigation. We're not going to touch it." So in effect, that doctor now has to work in a different way than he's used to through a PPO. If it's a work comp claim, of course, there's a lot of doctors that I don't touch work injuries. There's an entire system for workers' comp injuries that there's workers' comp doctors that treat on liens, or that are accepted within a network of workers' comp doctors for the employer or the employer's workers' comp insurance company. So don't be cynical about sending your client to medical treatment if they're hurt and injured and you have a doctor that can help them. Don't do that. You got to explain it to the jury, though. Okay. And then there's the concept of leaning in. And I want to give you a specific example. So I tried a jury trial in Long Beach a couple weeks ago. And we had a case where our client, again, it was a car crash, clear liability against the defendant. There were some issues with the case in terms of litigation, who the defendant was, all that kind of stuff. But the issue was, it was a case where we did have lien finance treatment. Okay. And the question was, well, are you going to hide that? No. That client was very near and dear to our office. So we leaned into not just the lien, but how the client found us. She happened to be the cleaning lady for the entire office building, right? Our office has, we're in a certain office suite of the entire building. And we said, listen, back when this crash occurred, 2019, she was the cleaning lady for the entire building. And she knew somebody in the building who worked for our firm and said, listen, I'm involved in a car crash. I've been trying to, get some justice in this case. I'm hurt. Here's what happened. It was a big impact. And can you help me out? I'm injured. And yeah, there's nothing wrong at that point. There's nothing wrong at that point with basically giving the client the opportunity, the option of treating with doctors that you have a prior relationship with, that work with on a lien, chiropractic providers, orthopedic surgeons, pain management doctors, whatever it may be. And so we took the case to trial. They offered us nothing. They said, we're not paying. And I was straight with the jury. You tell the jury, hey, here's how we met this person. Here's who she is. We're honored to represent her, not just because we're saying that, like most lawyers say that on every case, but here's why we're doing that. Here's why we're honored to represent her, because she helps us out. She's our cleaning lady, right? She makes sure that the bathrooms are clean, that the office, that there's no trash, and none of that. She does all that for us. And yeah, she didn't have health insurance. All that. Didn't have health insurance, right? She didn't have the cash to pay to go to an emergency room or to a doctor, right? She didn't have her own primary doctor. And so we provided her a list of chiropractors. We provided her a list of medical doctors. And she chose one of them who happened to be near her home. And then she treated. And she got better. And then after that, she got some x-rays and some MRIs. And then she went to an orthopedic surgeon. What's wrong about that? Nothing. There's nothing wrong about that. There's nothing wrong about that. And you know what? I asked the jury for $15,000. and they gave us $66,000. Now, whether we collect the full $66,000 is another question. But the point is, if you have a just case, don't mind game yourself by the insurance industry's line, which is often a lie, right? Nobody's going to tell you, oh, what you have you bought a home in Southern California for $700,000 and you didn't pay cash. You got a mortgage? How dare you? And it's an interest and what? Well, you got it. Well, you're not only people who have cash get homes. Same story with the medical treatment. That's the way that you have to approach a case. The truth. Don't let the other side mask the truth with their stories. If you have the facts on your side and you have the law, then if you are properly trying this case and you've done your homework, you tell the jury, you want to tell them everything. Okay, you want to tell them everything. Nothing is going to hurt you if the truth is on your side. Okay? You got to believe in that. You got to believe in your clients. And you got to know them. You got to get and meet them, break bread with them. I made a lot of videos on that. You know, you can read a deposition a million times, and you should probably not read it a million times, but you should read it, outline it, you know, page line it, all that kind of stuff, and make questions, cross-examination questions based on depositions of the other side, direct examination questions, get ready for redirect. All of that stuff is essential. But if you're not doing the human element, you're missing out on a lot. Again, lean into your case. If you're bringing a case towards a jury, it must be a just case. Give them everything. Lean in. Thank you.